Okay, good afternoon. Welcome to WG University, Weber Gallagher series of educational programs. This is a special edition of our employment webinar series. I am Julie Kinkoff and I am presenting today from our Philadelphia office. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the website www.wglaw.com. And there you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. Today's presentation is Overtime Rule Changes, the 2019 version, and what you need to know. So let's get started. So first of all, we're talking today about the Fair Labor Standards Act. The FLSA requires that employers pay a minimum wage. Currently, the federal minimum wage is $7.25. As you probably know, state minimum wages are often higher, sometimes significantly higher. The FLSA also requires that employers pay non-exempt employees 1.5 times the employee's regular rate of pay for all hours worked over 40 in a work week. And that's the requirement that we're going to talk about specifically here. There are also record-keeping requirements under the FLSA. Specifically, you must track hours worked by employees in each work week. So let's talk about the exemptions. So there are exempt employees and non-exempt employees. Non-exempt employees are hourly employees that need to be paid overtime for hours worked over 40 hours in a week. The most common exemptions under the FLSA are the so-called white-collar exemptions. These are your executive, your administrative, your professional employees, and your outside sales employees. It does not include inside sales employees. There are some other common exemptions, highly compensated employees, which we'll also talk about, and computer employees. It's important to keep in mind that we're talking about the federal law. There are also state laws that you must comply with, and the state laws can be different when it comes to overtime and minimum wage issues. One of those differences, for example, in Pennsylvania, is there is no exemption for the highly compensated employees. There also is no exemption in Pennsylvania for computer employees. So those, if you are in Pennsylvania, are not going to be available to you because you have to comply with both the state law and the federal law. In looking at these white-collar exemptions, there's a 3-part test that you have to satisfy, and you have to satisfy all 3 parts of the test. First, the employees must be paid on a salary basis. Second, that salary must meet certain minimums. That's the amount that's changing under the new regulations. Also, the employees must do certain job duties as it relates to each of those different types of exemptions. So if you don't meet all 3 of these tests, they are not exempt. We went through this before with changes in the with proposed changes in the overtime rates back in 2015. Many HR people will remember the pain of trying to comply with the Obama administration proposed changes, which included a more than doubling of the salary minimum, and also included some automatic updates. Now, as we all know, in the 11th hour, those changes were put on hold and stopped by a federal judge in Texas. So those changes never went into effect. A few things have changed since then. We have a new administration, we have a new Department of Labor Secretary, and we also have a new test for how you apply FLSA exemptions. In April, the United States Supreme Court decided this case called Encino Motor Cars LLC versus Navarro. Now, the issue in Encino Motor Cars really isn't something that's going to affect very many people. It had to do with whether service advisors are exempt under the FLSA. That's kind of a narrow issue. But in deciding that narrow issue, the U.S. Supreme Court made a very broad change to overtime and FLSA law. The old rule used to be that when you were looking at whether somebody is exempt or non-exempt, you needed to read the exemptions narrowly. That was because the FLSA is a remedial statute, and the thinking was, or the law was based on the fact that exemptions to a remedial statute should be read narrowly. U.S. Supreme Court said, no, that's not the way it works. The exemptions under the FLSA are as much a part of the purpose of as the overtime pay requirements, and because of that, you don't need to read them narrowly. All that's required is a fair reading of the law. This is important because, as anyone who's gone through this process before and tried to apply exemptions, there's some wiggle room there, and there's some gray areas. The old rule used to be, when in doubt, give them the employees the most protection that you can give them. The U.S. Supreme Court said all you have to do now is a fair reading. So that's a big change in the law. Now, that was in April. So the other big change are these proposed changes. The Department of Labor under the Trump administration just issued their proposed changes, their version of what the Obama administration was going to do in 2015. They just published them. There's a 60-day window to comment on them. So let's talk about what the changes are. First, they're changing the salary level thresholds for the administrative, executive, or professional employees. Now, they're not increasing them as much as Obama wanted to. They're increasing them to 35,308. So anybody who, makes less than 35,308 cannot be considered exempt for overtime purposes. The highly compensated, this is an easier test or a less stringent test that can be used for some employees. That amount used to be $100,000. They're proposing changing it to $147,414. Again, you can't use that one in Pennsylvania though, because it's not covered in the Pennsylvania state statute, and you need to comply with both. Both the Obama administration proposal and the Trump administration proposal provided for this non-discretionary bonuses. So part of some non-discretionary bonuses can be used to get up to those minimums. This isn't a large amount of money. It's up to 10%. So that would be about $3,500. So that's not going to make a huge difference, but that is available to employers. One of the biggest changes between the two proposals is under the Trump proposal, there's no automatic increases. Under the Obama proposal, we were looking at increases every year starting in 2020. The Trump administration has not included those automatic increases in their proposal. Instead, they're going to study it in 4 years. So let's talk for a second about the impact of these changes. Many more employees are going to be eligible for overtime. Anyone who's making between $23,660 and $35,308, regardless of their duties, can no longer be considered exempt. So you're going to need to look at those employees, and you're going to need to decide, they will now be entitled to overtime. So are you going to limit their hours? How are you going to address that? Another thing that's going to happen is tracking hours is going to be even more important, because you are going to have more people who are hourly employees and entitled to overtime. So you need to make sure that you have the systems in place to keep the necessary records. You need to make sure that your policies are up to date. And you need to make sure that you're providing the correct training to your line employees and your supervisors. So what if you get it wrong? The FLSA has some really bad penalties, and for violations, they include back wages, liquidated damages, attorney's fees, court costs, injunctions, civil penalties, criminal prosecution, everything you can imagine. There is even a hot goods provision under the FLSA, and under that provision, the Wage and Hour Division can seek to restrain a shipment of goods produced in violation of the FLSA. Now, that's not something that is used very often. In fact, I'm not familiar with it being used in any case, but that is something, that is a weapon that they have in their chest if they want to use it. Litigation for FLSA violations has increased dramatically over we'll see, we got a next slide has some numbers as far as lawsuits. But the other type of litigation, the investigations, have increased significantly. The highest percentage was in 2018, and that was the highest percentage of agency-initiated investigations. So an agency-initiated investigation is not where somebody makes a complaint. It's where the Wage and Hour Division says that they want to audit your records. And so they're initiating that investigation themselves. FLSA cases have increased. $400 million paid out in 2014. That's a lot of money. The amount of the settlements are going up, and the amount of litigation, or the amount of investigations and litigation that's started by the Wage and Hour Division, is also going up. So this gives you a sense of FLSA litigation over the last 10 years or so. As you can see, it looks like it peaked in 2015. That was probably at least partially related to the change in the law that was proposed by President Obama and the awareness of all of that change. So we may see another bump come up here in 2019 now that the issue has come up again. One thing to keep in mind, those numbers are for federal court litigation only. They do not include any of the state claims that are brought in state courts throughout the country. And since some states have far more favorable wage and hour laws, plaintiffs are more likely to go to state court than federal court. These lawsuits can cost a lot of money. Here are some of the big overtime lawsuits that were resolved in 2017. Those are some big numbers. One thing you need to do in order to avoid the penalties and adverse actions under the FLSA is to keep records of hours worked. The FLSA requires that you have to keep accurate number of daily hours worked by an employee. So what does that mean? Does that mean that everybody has to clock in and out every day? Not necessarily. I mean, there are exceptions and there are kind of allowances under the regulations for people who work a fixed schedule, so long as they continue to work that fixed schedule. If they change the fixed schedule for some reason, if they're out one day or that week, or they work different, less hours or more hours in a day, then you need to track those actual hours. Here are some of the common mistakes that employers make when it comes to FLSA issues. One of the biggest one is off-the-clock work. Supervisors have tight budgets and they ask employees to work hours but not record them. That is a big problem and can lead to serious liability and serious penalties for the employer. Another issue is after-hours work. We all have smartphones these days. Employees have smartphones. Employees after-hours work, checking their emails, getting their assignments for the next day, preparing materials, and not getting compensated for it. If an employee is an hourly employee, they need to be compensated for all hours worked. And so that after-hours work can be a problem. Another common error that employers make is to say, okay, we're just going to pay everybody a salary and nobody gets overtime. The problem with that is that you have to apply the duties tests. If they are not doing job duties that complies with the law, then you can't just pay them a salary to avoid overtime. Another issue that is a common problem for employers is relying on an outdated or inaccurate job description. So you have a job description which maybe, when it was written, the person was exempt from overtime based on the duties they were performing, but things change, people's jobs change, and the job that they're actually doing does not meet the description that's written. So maybe the job that they're actually doing does not meet the test for the job duties tests. When the government comes in and looks at these things, or when a plaintiff's attorney comes in and looks at these things, the written job description does not matter. It's what the employee is actually doing. The other, another common problem is improper salary deductions. As I said, everyone has to be paid on a salary basis, which means only certain deductions can be made from their paycheck, and if you make the wrong ones, that can be a problem. You should look to make sure that your handbook has a safe harbor policy, which essentially is we're gonna comply with the law. If we make a mistake, let us know, and we will fix it that sort of safe harbor policy can be beneficial to helping you maintain that salary basis protection. So we have these new proposed rules. What are we going to do about it now? You need to look at those employees who are in the danger zone. You need to see if they need to be reclassified. You need to find out what those employees are doing. How many hours are they working? You need to figure out what their regular rate of pay is and what their overtime rate of pay is, and how much these changes could cost you if someone is going to become eligible for overtime that isn't currently eligible for overtime. It's also important to raise awareness. Whenever you have employees who suddenly go from being salary employees to hourly employees eligible for overtime, that can be troubling for some people. Some people like to be considered salary and not have to track their hours and that sort of thing. So you're going to need to have an open discussion with not only the employees but your supervisors on the wage and hour policies of your company and how these changes are going to affect them. And as I'll say it again, make sure you're keeping accurate records. That is key. Going forward, you probably want to look at doing an audit of your employment practices and your payroll practices. You want to look at those job descriptions, make sure they're accurate. Job descriptions are important, obviously, for exempt, non-exempt purposes, but also for FMLA purposes, for ADA purposes. You really want to make sure that you have updated job descriptions. You want to look at your record keeping, and it's also a good time to look at your other classifications, your independent contractor / employee classifications. Now, it can be beneficial to have legal counsel involved in doing that. Opinion letters from attorneys can go a long way to show good faith if the government does come knocking at your door. It can help to address executive team concerns. It's always better to have somebody else give the bad news than have you give it. And, sometimes the attorney-client privilege can also be beneficial. So that's a summary of the changes that we're seeing here with the overtime rules. So thanks for attending this webinar, Overtime Rule Changes, the 2019 version, What You Need to Know. You can learn more about this program and other Weber Gallagher events by visiting wglaw.com. Thanks.